Hello, and welcome to Chesapeake Legal Alliance's Clean Water Act Fundamentals webinar. Thank you for joining us today. I am Hannah Brubach, staff attorney with the Pro Bono program. I will be your moderator this afternoon. We are so glad you are joining us today. As many of you likely know, Chesapeake Legal Alliance is a nonprofit organization that provides pro bono legal services to individuals and organizations working to protect the Chesapeake Bay. We do that with the help of our generous pro bono attorney network. This week is Pro Bono Week, a chance to celebrate pro bono attorneys nationwide for the free assistance they provide to those in need. Thank you to all of CLA's volunteer attorneys. Our presenters today are Molly Brown, Senior Attorney and Director of Legal Education, and Angela Herron, Senior Attorney and Director of Legal Innovation. As the standard disclaimer, I want to remind everyone that although we are lawyers, this workshop is not intended to provide legal advice. If you are looking for specific legal advice, we encourage you to go to our website, www.chesapeakelegal.org/help, to fill out our request for assistance form at the bottom of the page. After we receive the form, we will do our best to connect you with one of our staff attorneys or an attorney in our pro bono network. Before we begin, I want to go over a few logistics. This webinar is being recorded, and we intend to make it available on our website along with the slides from today. If you know of people who are interested in attending but were unable to join us today, they will have access to it on our website. The webinar is being hosted through Zoom, and as attendees, your microphones are muted. At the bottom of the screen, you will see a Q&A button. If you click on that, you will be able to type in any questions you have. We encourage you to type in as many questions as you have and as you have them. The presentation will last about 40 minutes, and we will have about 10 minutes at the end for Q&A. Before we begin, we have two polls, and I'm going to put them on the screen now. One moment. Okay. First, we would like to know a little bit more about you. How would you describe your work? Are you an attorney? Are you a law student? Are you in a non-legal profession? I'll give you a few seconds to answer this poll. Wonderful. I'm ending the poll now, and I'll now share the results. So it looks like we have a good amount of attorneys on the webinar and non-legal professionals as well. If you're an attorney, we hope this is a great opportunity for you to learn more about the Clean Water Act and how it applies in our local watershed, the Chesapeake Bay. And if you're a non-legal professional, we hope this webinar will empower you to learn a little bit more about how you can use the law moving forward. Going to stop sharing the results and move on to the next question. The second question is, are you part of CLA's volunteer attorney network? We'll leave this open to any attorneys or law students who would like to share. I'll give just a few more seconds to answer. I'm going to end the polling now. And now I'll share the results. So it looks like only a few of you are part of the attorney network, and most of you are individuals or community groups watching to learn more, and we're so glad you're here with us. If you're an attorney and you're listening in and you're not part of the network, we invite you to join our network. There's a volunteer form available on our website, and we will share it in the chat box for you to see. We are so excited to have new attorneys who are interested in learning more about our work and joining our work. And we invite you to come and work with us. We work alongside our attorneys a lot as CLA staff attorneys, and we trust you each with taking on your own cases as well. So we can't wait to work more. I'll stop sharing the results now. And now I'm going to pass it on to Molly Brown to begin the presentation. I hope you enjoy.
Thanks for the introduction, Hannah, and welcome everyone. We'll start out today with a quick roadmap for you so that you all know what you can expect from the next hour or so. We will begin with an introduction to the Chesapeake Legal Alliance and to the Chesapeake Bay Watershed. We'll talk about the history of the Clean Water Act, its goals, and its framework. We'll discuss the three main buckets of Clean Water Act related legal issues that CLA takes on. We will briefly introduce some of the other sections of the Clean Water Act so that you know that they exist, even if we don't get into them in detail here this afternoon, as well as offer some resources for you to utilize in the future. And then we plan to leave about 10 to 15 minutes for questions and answers, depending on how our time works over the presentation. Angela and I are going to be trading back and forth during the presentation, so you'll be hearing from both of us and seeing both of us over the course of the next 45 minutes or so. Now, before we get into the meat of the Clean Water Act, I just wanted to take a minute to introduce you to the Chesapeake Legal Alliance. As Hannah mentioned, we are a small nonprofit organization based in Annapolis, Maryland, and we provide pro bono legal services to people and organizations throughout the Chesapeake Bay watershed. Our mission is to apply the power of the law to protect and restore clean water and promote healthy, resilient ecosystems for communities across the watershed. We provide free legal services through our staff of 7 attorneys, as well as through a network of over 200 volunteer lawyers. And those lawyers are licensed in every watershed jurisdiction. CLA offers direct client counseling, case development, and representation in local, state, and federal matters through our Direct Client Services Center. We also provide strategic policy counseling and innovative legal analyses of issues that arise in the course of the protection and restoration of the watershed. Lastly, and why we are here today, we provide objective legal education and training to people and communities in order to empower individuals, our partners, and our volunteer network attorneys to use the law to protect local water quality. While this presentation is going to be a general overview of the Clean Water Act, we will be using the work that CLA specifically does within the Bay watershed as examples to ground some of this discussion. Now, we know that not all of you present here this afternoon live and or work within the watershed. So while we may be using local examples, the underlying ideas that we're discussing today are applicable on a national level. Before I hand it over to Angela, I want to give a brief introduction to the Chesapeake Bay and its watershed in case there are people present who are unfamiliar with the area or the term. The Chesapeake Bay is the largest estuary in North America. An estuary is a body of water where fresh water from rivers and streams mixes with salt water from the ocean. I've put these stars on this map on this slide to orient those of you who aren't familiar with the geography to where we're talking about when we talk about the Bay specific. The large white star you see on your screen is Washington, D.C. The small orange star to the east is Annapolis. The red star above Annapolis is Baltimore. If you look down towards the lower section of the map, the green star is Richmond, Virginia, and the blue star to the east of that is Norfolk, Virginia. So you can see that the Bay runs from the northern part of Maryland, where the Susquehanna River enters into it, down through Maryland and Virginia, and out into the Atlantic Ocean. The total shoreline of the Bay is about 11,680 miles, a little bit more than that, which, to put it into perspective for you, is longer than the distance from San Diego, California to Seattle, Washington. So the shoreline of the Bay, if you add it all up, is actually longer or as long as the west coast of the United States. The Bay itself is a major environmental, recreational, and economic resource for the people and communities that inhabit and utilize its shorelines and waters. It's also home to countless plant and animal species. However, when we talk about bay water quality, we are not just talking about the Chesapeake Bay proper, what you see on this map. Instead, we are talking about water quality throughout the entire Chesapeake Bay watershed. The term watershed refers to a geographic area of land that drains into a specific body of water. What that means is that rain or snowmelt or any other introduction of water onto land that drains or sheds into your local storm drains, streams, rivers, ponds, etc. That water goes into those small bodies of water. Those smaller bodies of water drain into larger bodies of water, and so on and so forth, until that water reaches a lake or an ocean, or in our case, a bay. As you can see from this map, the Chesapeake Bay watershed is huge. It covers approximately 64,000 square miles of land, and it includes parts of New York, Pennsylvania, Delaware, Maryland, Washington, D.C., West Virginia, and Virginia, 7 jurisdictions altogether. More than 18 million people live within that watershed area that you see highlighted on this map. So when we're talking about the Bay watershed, we are talking about much more than that Chesapeake Bay itself. As we continue on with the presentation, remember that the Clean Water Act implementation happens on a national level across the United States. Here, how the act is implemented across those 7 Chesapeake Bay jurisdictions that I just mentioned has real implications for the health and restoration of that one specific water body, that bay. Okay, now that we've gone over a few of the background fundamentals, I'm going to turn it over to Angela to talk more specifically about the Clean Water Act.
Thank you, Molly. So before I dive in, I want to mention that the Clean Water Act is not just a static federal law. This makes things interesting and sometimes complicated. The structure and application depends on regulations, interpretation, and guidance from the U.S. Environmental Protection Agency, which can evolve and change over time. Because the president appoints heads of federal agencies, through the years, we've seen dramatic shifts on how the Clean Water Act is used and enforced, depending on the priorities of different administrations. This is mirrored at the state level, where enforcement and application of the law can also change as political priorities shift. Additionally, courts decide lawsuits that can also involve statutory interpretation, which can then set new precedents. For example, there was a recent Supreme Court case, County of Maui versus Hawaiian Wildlife Fund, which expands the types of discharges that are covered under the Clean Water Act. If you want to learn more about that case, we have a blog about it up on our website. For those of you who may have participated in the enforcement webinar we gave earlier this year, some of the next few slides may look a little familiar, but I promise we'll be covering some new material too. The Clean Water Act is almost 50 years old, and understanding the historical context is important to understanding its purpose. Around the time it was passed, it was estimated that only 1/3 of US waters were safe for fishing and swimming. Pollution was rampant throughout the United States, and 2 catastrophes in 1969 are credited with sparking the modern environmental movement and our bedrock environmental laws. In January 1969, the Santa Barbara oil spill off the coast of California blackened over 12 miles of beaches. It devastated wildlife, recreation, and the fishing industries. At the time, it was the largest oil spill in US history. Now it ranks 3rd behind the 2010 Deepwater Horizon spill and the 1989 Exxon Valdez spill. Then in June 1969, the Cuyahoga River in Cleveland, Ohio, caught on fire. Oil slicks were common on the Cuyahoga, and it wasn't the first time it caught fire. But this time, the media publicized it. Time magazine ran an article, and this media attention fueled public outcry on the need for tougher pollution controls. So in 1971, the statute that we now know as the Clean Water Act passed the US House and Senate, but President Nixon vetoed it over economic concerns. In 1972, the House and Senate came back together for a bipartisan vote to override this veto. The override was led by Senator Edmund Muskie, who asked on the Senate floor, can we afford clean water? Can we afford rivers and lakes and streams and oceans which continue to make possible life on this planet? Can we afford life itself? So these questions are as relevant today as they were nearly 50 years ago. The Clean Water Act's overarching goal is to prevent, reduce, and eliminate pollution to restore the chemical, physical, and biological integrity of the nation's waters. It set ambitious targets, including water that's clean enough to protect fish, wildlife, and recreation by 1983. This is where we get the fishable, swimmable standard that you may have heard of. And just 2 years later, by 1985, the elimination of all pollutants into navigable waters. So unfortunately, we didn't reach those target dates, but we really have come a long way. And by setting ambitious targets, Congress expressed commitment to protecting our water. A key way to achieve these goals is through water quality standards, which describe a desired condition of a water body and the means by which that condition will be achieved. Water quality standards form a legal basis for controlling pollutants entering the water. They include 3 specific components: designated uses, water quality criteria, and anti-degradation. A designated use are things like protecting fish and wildlife, recreation, drinking water, as well as agricultural, industrial, and navigational uses. Water quality criteria is a description of the amount of a pollutant that a water body can handle and still be considered safe for one of those designated uses. Now, water quality criteria can be either numeric or narrative. Numeric criteria set a maximum pollutant concentration. For example, in Maryland, where I live, the concentration of Enterococcus bacteria is 130 mpn per 100 milliliters in order to be considered safe for human consumption. Numeric limits are generally easier to enforce because they're quantifiable. You can test the water and know whether you are under or over the limit. Narrative criteria, on the other hand, are statements that describe a desired water quality goal. For example, being free from oil or odor. Narrative standards are typically harder to enforce because they can be somewhat subjective. When a water body doesn't meet water quality criteria, it is considered impaired, and a plan is required under the Clean Water Act to clean it up. This plan includes setting total maximum daily loads, or a TMDL, for a specific pollutant. The third component to water quality standards is anti-degradation. The Act requires that states have extra protections for water bodies that are already cleaner than water quality standards. Anti-degradation really helps to prevent lowering of water quality. The Clean Water Act starts with the premise that discharging pollutants into waters of the United States is prohibited. However, our modern day life makes that extremely challenging. Things like wastewater treatment plants, stormwater runoff from paved surfaces, or industrial processing all have byproducts. Recognizing that some amount of pollution was likely inevitable, the Clean Water Act sets out a permitting scheme whereby an entity can apply for permission to pollute a certain amount under certain circumstances. Violation of the Clean Water Act carries the potential for both civil and criminal penalties. Importantly, public participation and public enforcement are codified into the language of the law. This means the public has the right to participate in and to enforce the requirements of the Clean Water Act. This right to participate and enforce is really critical to the effectiveness of the Clean Water Act. It's also very important to many of the partners we work with throughout the Bay region. We have many clients who approach us for help with enforcement. There are multiple levels of government involved with the Clean Water Act. First, US Congress passes federal laws and here, as you know, passed the Clean Water Act. Then it is up to EPA to implement the law. EPA creates regulations and writes rules to help define the scope of the act and creates guidance for states. EPA also has authority to issue permits. These are the permits that I mentioned earlier that allow an entity to pollute a certain amount under certain circumstances. EPA also approves the Clean Water Act permits that states issue. EPA can set federal water quality standards and also reviews and approves water quality standards that states set. So although EPA has all of this authority, the agency recognized it would be too much work to do all of this for the entire country. So it delegated some of the responsibility for administering the Clean Water Act to the states. Not all states in the US have this delegated authority, but most do. And here in the Chesapeake region, all of the states have delegated authority. The only exception is Washington, DC, which US EPA still issues and oversees permitting. So states themselves who have this delegated authority can issue and enforce permits. They can set their own water quality standards as long as they meet the federal minimum. And they can also set TMDLs, which Molly is going to discuss in more detail momentarily. So this is important for our purposes because although we're dealing with a federal statute here, most of the time we're also dealing with state and then also local agencies, and in some cases in state courts. So with that, I'm going to turn it back over to Molly.
Thanks, Angela. So our clients and partners and communities come to CLA with a variety of different Clean Water Act related legal issues. But really, there are three main buckets of these issues that we deal with the most. So those are the three that we're going to go into in the most detail this afternoon. But they are not at all, and they're not at all the only things that we deal with. The three main buckets include the Chesapeake Bay TMDL, or Total Maximum Daily Load, NPDES permits, or National Pollutant Discharge Elimination System permits, and that third bucket is Clean Water Act public participation and enforcement issues, which is really kind of an A and B there. I'm going to start with talking about the TMDL. A TMDL, or a Total Maximum Daily Load, is often referred to as a pollution diet for a body of water. Pursuant to Section 303D of the Clean Water Act, states must identify water bodies that are not currently meeting the water quality standards applied to those water bodies, and then put that body of water on a pollution diet. If you remember when Angela was talking about impaired waters a few slides back, those are the waters to which these pollution diets apply. That means that the state needs to establish a total maximum daily amount, or load, TMDL, of whatever pollutant or pollutants are preventing that specific body of water from meeting its established water quality standards. And then the state needs to take steps to reduce that specific pollutant. Traditionally, a TMDL is limited to one water body. However, in 2010, EPA established a Chesapeake Bay-wide TMDL. The Bay TMDL is historic in its multi-jurisdictional breadth. It's the largest ever established by EPA. Not only does it cover more than one water body, but it covers all of the waters of the United States located within the Chesapeake Bay watershed, that 64,000 square miles that we were discussing earlier, which means it demands multi-jurisdictional and multi-agency cooperation in order to be successful. The Bay TMDL sets pollutant reduction goals on the amounts of nitrogen, phosphorus, and sediment released into waters that drain into the Chesapeake Bay, meaning that this specific TMDL applies to all 7 watershed jurisdictions. Just as a side note, the multi-jurisdictional effort to restore and protect the Chesapeake Bay is so unique that it's actually codified directly into the Clean Water Act. Section 117 of the Act discusses the Bay specifically, the Chesapeake Bay Agreement, the Chesapeake Bay Program, funding, among other specific Bay-related issues. Now, we're not going to get much farther into that complicated topic today because the Bay TMDL could easily take this entire hour to go into in detail. However, we wanted you to be familiar with the term as related to the Clean Water Act, because if you are doing any work whatsoever on water quality issues within the watershed, either as a lawyer, a community member, or a partner organization, you are certainly going to hear this term used. We also are planning to offer an intro to the Bay TMDL webinar early next year, early in 2021. So if it's a topic that you are interested in learning more about, please make sure that you are on our mailing list so that you'll receive notifications about it. I'm going to hand it back to Angela to talk about those other 2 buckets.
Great, thanks, Molly. So now we're going to discuss permits in more detail. The Act prohibits discharge of pollutants by a point source into waters of the United States without an NPDES permit. This is covered under Section 402. And let's just take a moment to break this down. So you can think of a point source as discernible, confined, and discrete conveyance. The definition of a point source is in Section 502 of the Act, and it lists examples but also makes really clear that the list is not exhaustive. Common examples are things like a pipe, ditch, channel, or animal feeding operation. Now, it is important to note that within the definition of the act, within the act itself, agricultural stormwater discharges and return flows from irrigated agriculture are expressly not included as a point source. If something is not a point source, it is called a non-point source. There really is no definition. It exists by exclusion. So if it is not a point source, then it's a non-point source, and it's treated differently and is addressed in section 319 of the Act. So I'm not going to get into a lot of detail on that today, but it is important for you to know that non-point source pollution really makes up a significant portion of the pollution that we deal with. Going back to section 402, we know that point sources are not allowed to discharge pollutants into waters of the United States without a permit. The logical question then follows, what is a water of the United States? Well, this definition was set by EPA and remained unchanged for many years. But then as political priorities shifted and the administrations changed, EPA passed new rules that changed the definition. So this so-called WOTUS, or Waters of the United States rule, narrowed the scope of the waters of the United States, thereby leaving some waters that were previously covered under the Act now unprotected. It also caused a lot of confusion for individuals seeking permits and for state agencies who issue these permits. So this WOTUS rule has sparked many lawsuits, which are still ongoing. Broadly speaking, there are two types of NPDES permits. There are general permits and individual permits. A general permit is written so that many facilities can apply for coverage under it without having to get their own specialized permit. When we refer to a facility as having a general permit, we mean they have applied and been granted coverage under just one general permit for the state. Now, general permits save agency time because they don't have to write and enforce thousands of different permits with different requirements. These general permits are often harder to enforce by virtue of how they are written. So not all activities that we would consider harmful to the environment are deemed actual violations of the permit. General permits set standard requirements for certain types of facilities. For example, you will hear people refer to the general industrial stormwater permit or the general construction stormwater permit. So contrasted with that are individual permits. These are issued to a specific facility, and they're often based on whether that facility is in a particularly important location or if the type of pollutant that they release is particularly dangerous. So if there is a high degree of complexity and individual nature of operations, or the impact is particularly potentially severe, then it might not qualify for a general permit, and it will be required to seek and get approved for an individual permit. So these types of permits, these individual permits, typically have stricter controls and can potentially be more straightforward to enforce than the general one. Now, there are common sectors of activities that are regulated by NPDES permits. Knowing what these are is important because depending on your state structure, different divisions within an agency might administer the permitting program. So permit areas include animal feeding operations. You'll hear them be referred to as AFOs. You may also hear CAFOs, which stands for concentrated animal feeding operations. There's also industrial wastewater. An example here could be a metal recycling plant. There's municipal wastewater, and this is the wastewater treatment plant that treats sewage. We also have construction stormwater, and this is for construction sites over 1 acre, as well as what is referred to as an MS4 permit. Now, this stands for Municipal Separate Storm Sewer System, and it really encompasses the storm drains you see on city streets. Chesapeake Legal Alliance works on legal issues with clients in all of these permitting areas. So public participation is a very powerful component of the Clean Water Act. Much of the work Chesapeake Legal Alliance does with clients is based on the provisions that allow the public to be involved in the administration and enforcement of the Clean Water Act. Codified into law is the public's right to participate and be part of this process. Section 101E requires the EPA and the states ensure that the public are able to be involved in the development, revision, and enforcement of any regulation under the Act. There are opportunities for public comment through public hearings, where you can stand up and provide oral testimony, as well as opportunities to submit written comments. This is true for both proposed regulations as well as for issuing permits. Public participation is so critical to ensuring that voices are heard. Much of the time, in fact, maybe most of the time, the burdens of pollution fall on people with less political power. It's up to all of us to lift up voices of community members who are impacted and might not know that they have this right to participate, and to speak up and protect clean water for themselves and for their communities. The second critical role for the public to participate is through enforcement. Section 505 explains that any citizen may commence a civil action on his or her own behalf against any person who is alleged to be in violation of the Clean Water Act. It also provides for suits against the government for failure to act on a non-discretionary duty. In this instance, citizen is defined as a person or persons having an interest which is or may be adversely affected. The person need not be a US citizen. There is, however, a requirement that the person have an interest which is actually harmed in some way. This gets us to the concept of standing, which is the legal term of whether or not you have the right to bring a case in court. There are, broadly speaking, two categories of citizen suits. Suits against a private entity. For example, these can be cases where a facility that is discharging pollutants without a permit, or perhaps they have a permit but are not following the requirements on the permit. These types of suits start with a 60-day notice letter where you give the entity notice that you intend to sue them. These cases can be in federal court. And going back to the legislative history of the Clean Water Act, we can see that Congress really intended the federal and state governments to be the primary enforcers of the Clean Water Act, but that citizens would also play an important role in filling the gaps that remain. And truly, citizen enforcement suits have played a big role in Clean Water Act enforcement. Historically speaking, most of the large penalties assessed under the Act have resulted from citizen suits, not necessarily by enforcement actions brought by EPA or the Department of Justice. The second type of case is against the government. We see these types of cases when a citizen or citizen group challenge an agency's issuance of a permit. For example, here in Maryland, several organizations challenged Maryland Department of Environment's issuance of the last MS4 permit, that municipal permit we discussed. So note that NIPD's permits are supposed to be renewed every 5 years. So this opportunity comes along every 5 years, essentially. Citizen suits can also be brought against an agency for rulemaking. As I mentioned earlier, a number of groups filed lawsuits against EPA for the WOTUS rule that redefined water of the United States. So I want to note that while there are certain things outlined in the Clean Water Act that are required of EPA, and by extension, those states with delegated authority, other things are discretionary, meaning the agency can choose whether to do it or not. And courts give agencies a lot of deference. So challenges against an agency can be difficult to win. Our goal today was to give you a brief overview and go somewhat in depth on a few aspects of the Clean Water Act that impact the work of CLA's Pro Bono Network and our client partners. There are several other important sections of the Act to be aware of. We put a small list here of a few more sections. Some of these we may provide future webinars on. And certainly if you have questions about them, we can also point you to resources. So just to briefly review this list, Section 303 addresses water quality standards, which we touched on briefly. Specifically, Section 303D discusses impaired waters and TMDLs. Section 311 addresses oil and other hazardous substances. Section 319 discusses non-point source pollution. Section 401 gives states and authorized tribes the authority to grant, deny, or waive certification of proposed federal licenses or permits that may discharge into waters of their state. So this section can be important for projects such as large natural gas pipelines. Section 404 covers permits for projects that impact wetlands. And this is another section that has evolved over time as well. So with that, I will hand it back over to Molly.
Thanks, Angela. So as Angela just mentioned, this has been a truly introductory style webinar, and we know that there are topics that we flew through and some that we only briefly touched on. As we've mentioned a few times now, this is only the first of several educational webinars that we will be presenting over the next year or so, specifically on the Clean Water Act. So if you are interested in diving more deeply into one of the subjects we talked about today, please keep an eye out for those. In the meantime, there are many resources available to you that can provide you with more information now. A few of them that we wanted to highlight include, well, the Chesapeake Legal Alliance website. We have many resources available on our website, including very soon a video of this webinar if you want to return to it, or if you have a colleague who wasn't able to attend in person today. You will also find links to previous Clean Water Act related webinars that we've done, our Citizens Guide to NIPD's permitting, information on public participation in permitting processes, groundwater permit and spray field advocacy opportunities, and many more resources. I also would be remiss to not mention the Clean Water Act Handbook, edited by Mark Ryan. This book has been an educational staple in the Clean Water Act world for a long time, and I'm convinced that Angela actually sleeps with hers under her pillow. She has that thing at the ready 24/7. Lastly, the EPA website has a lot of really good information about the Clean Water Act generally, as well as Bay-specific information. So I'd encourage you to check that out. And that is certainly not an all-inclusive list. There are many, many more resources regarding the Clean Water Act available to you online. So with that, we are done with the presentation portion of the webinar. I know we've had several questions come in. Hannah, if you can let us know what some of them are, I'd appreciate it. And if it looks like we're running well on time, but if we don't get to your question today, please feel free to reach out to either Angela or me, and we will make certain to either get you an answer or at least find someone at CLA who can answer it for you.
Sure. So we had a few questions come in before the webinar as well, Molly, and I would like to start with one of those. And I think Molly, you can probably answer this question the best. The question is, I am interested in learning more about navigable waters and how the congressional power of the Commerce Clause interacts with Maryland law.
Okay, that's a great question. Thanks, Hannah. And while I'm trying to answer it, if either Angela or Hannah, if you have anything to add in, please feel free to throw in your 2 cents. So waters of the United States, WOTUS, and navigable waters, those are terms that you are going to hear all the time when you are talking about what the Clean Water Act applies to. So this gets back to Angela's point at the beginning of the water. The implications of the Clean Water Act are filtered through several different layers before they actually make a difference on the ground. So we have the federal statute, we have EPA's interpretation of the statute, we have state agency interpretation of the statute, and then importantly, at the end of it all, we have judicial interpretation of the statute. So EPA interprets Clean Water Act language where needed through rules and regulations until someone says, hey, that's not what the law says, or that's not what Congress meant when they wrote that into the Clean Water Act, and takes them to court over it, which is what happened several times regarding the breadth of waters that the Clean Water Act actually applies to. So when we talk about the terms waters of the United States and navigable waters, we're talking about a source of constant argument. Polluters want those terms defined narrowly so that they don't have to comply with federal law and regulations, right? And environmentalists want those terms defined broadly to ensure that the Clean Water Act offers protections to as many waters, to as much ground as possible. So the interpretation, how we are interpreting, how we are defining waters of the United States, what is a navigable water, is a constant battle. The most recent Supreme Court case to address this issue was Maui versus Hawaii Wildlife Fund, which I know Angela mentioned earlier in the presentation. That was decided last April. The question in that case was, does the Clean Water Act require a permit if a pollutant originates from a point source, so yes, that would be, that would require a permit, right? But then if that pollutant ends up in a non-point source, and then that non-point source takes it to a navigable water. So does that still count as a discharge into a waters of the United States? And the non-point source that they were talking about in the Maui case was groundwater. In the Maui case, the Supreme Court said, yes, that does still count as a discharge into a water of the United States, and therefore requires a permit under the Clean Water Act. Now, this is a win for us. This is a win for us as environmentalists. Now Maryland has to, getting back to the original question about how this kind of influences Maryland law on the ground, Maryland has to apply that interpretation, the Supreme Court's most recent interpretation of what a waters of the United States is, what counts as a navigable water, to their permit, to the state's permitting scheme specifically.
Yeah, I think that was pretty thorough, Molly. I would just add that some states, and Maryland does as well, their definition of waters of the state is more broad than the federal definition. So in the
really
case
good point,
of
Angela.
Maryland, so in the case of Maryland, groundwater is considered waters of the state. So, you know, there are rules around that, but it doesn't mean that Maui isn't going to impact, you know, Maryland. It may very well. So
it's a really good point. Maui impacts national. Remember, we're talking about specific or local examples that are applicable on a national level, right? Maui will impact the way states across the nation are applying their Clean Water Act regulations and permitting schemes.
Yep, absolutely.
Yeah, and thank you, Angela. That's a great segue to the next question we have. So can someone, Molly or Angela, please explain a little bit more about the definition and the implication of WOTUS? I know we went over it a little bit during the webinar, but maybe we can expand on it.
Yeah, I will take that. But yes, again, we're all just a great team here, so chime in, please. So there really has been a lot of back and forth between rules from EPA and then revisions to those rules, as well as numerous lawsuits. In April of this year, actually the latest, EPA published yet another revision of WOTUS, and this is dubbed the Navigable Waters Protection Rule. So again, as I mentioned before, new rules, and these new rules have caused a lot of confusion for permittees, for permit writers, and for enforcers. So the proposed changes in the latest rule narrow the scope of what water is considered subject to the Clean Water Act, and therefore under what circumstances a permit would be needed. So this is really fundamental, because if you're required to get a permit to operate, if you're required to get a permit and then you operate without one, then you're subject to liability. If you need a permit, then you can just operate without one. The proposed 2020 rule has 4 types of waters that are explicitly covered under the Clean Water Act. So those include territorial seas and traditional navigable waters, perennial and intermittent tributaries to those waters, lakes, ponds, and impoundments that contribute surface flow to territorial seas, and then wetlands that are adjacent to jurisdictional waters. But this 2020 rule also explicitly excludes 12 categories. I don't have them all here, but a few ones to be aware of that it excludes is groundwater, including groundwater drained through subsurface drainage systems, ephemeral streams and features that flow only in direct response to precipitation, ditches, including agricultural ditches that are not constructed in adjacent wetlands, and then prior converted cropland. And so again, there are more, and you can look them up online. But so as Molly just mentioned, in the Maui case decided this year, the Supreme Court found that the Clean Water Act does require permit if the addition of pollutants through groundwater is what we call the functional equivalent of a direct discharge from a point source into navigable water. And then the court went on to explain what that test of functional equivalency means. So what we've just described here, right, is a bit of a conflict, because you have the Supreme Court saying one thing, and now this new rule ostensibly saying something. So what we're really seeing in real time is the complexity of how the various branches of government can impact the scope and application of the rule. And, we'll just have to stay tuned and see when and how this issue is going to be settled. EPA can also rescind rules and change rules. Obviously, we've seen all that. So there's a chance that whenever it is we have a new administration, potentially quite soon, the priorities of EPA might change, and then this definition could change again. So it really is a living law.
Thank you. And while you're talking about the Clean Water Act and some of the different ways to challenge cases or permits, would you mind reviewing again whether you have to be a citizen to file a citizen suit complaint?
Yeah, sure. I will take that. I think I also might have typed it into the chat too. So the answer is no, and this is really important. You do not have to be a United States citizen in order to bring a citizen suit. So we say citizen suit because it's a legal term of art, but it is important to be really conscientious of our language, and we do try very hard to only use that word when we mean it. We don't want to exclude people who have different immigration statuses. But in this case, citizen suit is a legal term of art, how it's discussed within the act. So yes, so spread that far and wide, that you do not have to be a US citizen. And also, maybe take that into your consciousness and be careful when you're using that word. Try to avoid using that word, because unfortunately, I think it has taken on a different meaning in our political climate right now. So try to avoid that word unless you need it.
Thank you. And another continuation, following up on the inclusion of groundwater in WOTUS by Maryland, do you know, or does Molly know, or anyone else, whether Pennsylvania views groundwater as included in WOTUS or a state waters of the Pennsylvania rule?
I am not as familiar with Pennsylvania state law, but that is, I wish one of our colleagues was here. I know he could answer it right away. We can certainly.
We can
we can
follow up after the
follow up
webinar.
with that
I
one.
think it would be found in the Clean Streams law. So maybe we can look into that and get back to you after.
And if
So-
anyone from Pennsylvania on the webinar knows the answer to that and wants to type it into the question and answer section, we also are accepting answers.
Thanks, Molly. So the next question is, how do I become a pro bono attorney? And if I know someone who is looking for assistance, how do they go about getting to be an attorney through CLA? I'll go ahead and answer this one. My name is Hannah Brubach, and I'm a staff attorney with the Pro Bono program, in case you joined late. And the Pro Bono program works to not only intake the cases, but to place them with the attorneys in our network. We currently have a network of about 150 attorneys and law firms that we are actively placing cases with every month. To get on this list, you can fill out our form that I believe should still be in the chat at chesapeakelegal.org to become a volunteer. There's no requirement when you become a volunteer to take on cases. You'll receive a newsletter about once a month that explains the pro bono opportunities that we have that have come through our partners, many of whom are on this call, others who are not. And we share very minimal information to avoid any conflicts issues, but we describe the issue that they are seeking assistance on and the legal type of issue that they need resolved. This can be anything from a 501c3 formation to employment law assistance or permit challenges. It can be environmental, corporate, employment, really anything. And we believe that helping the environmental organizations in the Bay watershed with corporate and employment issues allows them to spend that money that they may have to use resolving a legal issue on their more important work of protecting and restoring the Chesapeake Bay and its tributaries and the communities. So we really have a wide range of opportunities. We don't just work with environmental attorneys, and we also offer a lot of environmental attorney work. So please reach out to me if you have any questions. I can drop my email in the chat box as well, and I would be happy to have you join our attorney network. And with that, I'll move on to another Clean Water Act question that kind of broke it up a little bit. Can someone explain a little bit more about Section 117?
Yeah, I can try to tackle that. I know that we touched on Section 117 a little bit in the webinar. Section 117 of the Clean Water Act, it was added to the Clean Water Act originally in 1987, I believe. It is specific to the Chesapeake Bay. It establishes the Chesapeake Bay program, as well as the program's duties under the Clean Water Act regarding the Bay. Section 117 was the basis for the lawsuit in 2010 that ended in a settlement agreement with EPA establishing the Bay TMDL. So it's interesting to know that EPA is currently the defendant in a similar lawsuit brought by Maryland, Virginia, DC, and Delaware. Those jurisdictions are claiming that the federal agency is again failing to comply with its duties under 117 because it isn't ensuring that the other states that are part of the Chesapeake Bay Agreement are developing and implementing plans that will help them be successful in reaching their TMDL goals. So Pennsylvania and New York, pretty much. This, those goals, that gets us dangerously into the realm of watershed implementation plans, or WIPs, which are a topic that we will address in a TMDL specific webinar. We're not going to get into them here because they are, it gets confusing very quickly. But I think that the point that you should all take away from this is that it's easy to assume that something is going to happen because it's written into federal law, right? And the reality is that we are still litigating over what EPA's duties are under Section 117. Despite it being originally added to the Act, 33 years ago. So, it's always up for interpretation. Well, some people think it's always up for interpretation, but that's, I think, 117 again could be a whole nother topic for an entire hour-long webinar.
Sure. Building off of this question, either Angela or Molly, you could continue answering. What is the difference between the water quality standards set by EPA and the TMDLs that are implemented by the EPA and the TMDLs implemented by the states?
Sure, I can try to
Angela,
explain that.
I think that's a question for you.
So what are the difference between the water quality standards set by EPA versus the states, and how do those relate to TMDLs? Is that the question?
Yep.
Okay, so as I mentioned, EPA can set water quality standards, and then that is somewhat of a floor. So states can set their own water quality standards that are stricter. Or, in the case if EPA doesn't have a water quality standard for a certain pollutant, then the state could create one on its own. So as long as the states have not done something that is less restrictive than what EPA has given guidance on, then the states are free to have stricter controls. EPA also plays a role in approving whatever the water quality standards are that the states set. So, and yeah, this is a bit of a complicated process with a lot of jargon, but essentially, first a water body is designated. So first we have designated uses for water bodies. And then we say, this is a water body that we're going to be using for swimming. And then we say, okay, well, in order to swim, like the example that I used, we can't have Enterococcus bacteria over 130 MPN per 100 milliliters. Otherwise, it would be unsafe for humans to swim. So that is that's our water quality criteria under these water quality standards. So we know that the water body should be used for swimming. We know what the threshold is, and then tests should be done to see whether we're over or under that limit. We have state agencies that do water quality testing. We also have a lot of the partners that we work with, a lot of water people organizations, for example, run water quality sampling, which is really, really important. And we determine that this water body frequently is above this threshold. And so then they go through this process, and this really kind of goes into the 303D process, section 303D that we mentioned. We intend to do a webinar, again, just on this because it's kind of, as you can see from my answer, it's detailed. So we know there's a designated use, we know what the standard is, we test the water, and then we determine that indeed this water body is impaired. It means it doesn't meet these water quality criteria. It's got way too much fecal bacteria in here. Those of you who don't know, Enterococcus is fecal bacteria, so we're often talking about raw sewage. Therefore, it is impaired. So once it's impaired, then it gets on this, what we refer to as section 303D impaired list of water bodies that need a plan to clean up. So we've identified the use, we know that's too dirty, now we need a plan. And so the plan is really the TMDL. So these TMDLs get written to say, you know, here's the maximum amount of the pollution that can enter this water body, and here's this pollution diet can then get essentially divvied up by all of the different users who pollute into that water body. When they have a permit, their permit will say, okay, you plant over here, A, can only, you know, release X number amount of this pollutant. And then you over here, plant B, can only release, you know, and I've lost my Y amount. And so all in total, the amount of pollution that's entering the water body is within that diet limit. I hope that made sense. But to answer your question, that all usually happens at the state level. So the states are doing all of that. And then once the states are done, they send it to EPA, and EPA says, yes, you did a good job, or no, you didn't do a good job.
Wonderful. Thank you.
Anybody else want to
Angela.
jump in or explain it?
No, I think that
Okay.
summed it up really well.
Yeah, I think you did a great
All
job.
right.
Now we're
Okay.
just about out of time, so I'm going to call an end to today's webinar, but please send us any other questions you have and we'll be happy to answer them. We have a few other questions that we did not get to today, and so hopefully we can follow up with a few answers on the website where you find this video. So thank you everyone for attending today's webinar. Again, a reminder, if you need legal assistance, whether it be a corporate question, an employment question, a permit challenge, a pollution investigation, or anything else, please reach out to us on our website at www.chesapeakelegal.org/help. And we look forward to seeing you all soon.
Thanks, everyone.